The next case set for argument today is case number 18CA0108M, State of Ohio versus Gary McCain. Both parties are represented by counsel here. So each will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes. I'll keep track of the time and let you know if you're going to reserve time. Let me know and I'll keep you appraised of that. No children involved in this one, as I recall, correct?
No children.
There's a child victim.
There is a child victim? Okay, so let's use initials if we have to refer to them.
I think I did.
We've read the briefs, we're ready to proceed if you are. So, Attorney Ryan.
Ryan, thank you, Your Honor. May it please the Honorable Court, my name is Attorney Thomas Ryan. I represent the defendant appellant, Gary L. McCain Jr., and if I may, I'd like to reserve 5 minutes for rebuttal, if I may.
Very good, thank you.
I'm going to ask this Honorable Court of Appeals to reverse the trial court's finding that there was clear and convincing evidence that appellant committed the offense of rape in this case. So, how do we get here? Mr. McCain was indicted in a 3-count indictment, rape with a furthermore specification, gross sexual imposition, and kidnapping. On July 3rd, 2018, there's a referral to have Mr. McCain, the defendant appellant, evaluated for competency. That was done, and on September 5th, 2018, parties returned to court, and the parties stipulated that Mr. McCain was not competent and would not be able to be restored to competency within a year. There was then another evaluation done of Mr. McCain to determine whether he is subject to institutionalization under Revised Code 5120, and the state made a motion for the trial court to retain continued jurisdiction. So it required a hearing. So the court went forward on a hearing. The state presented a total of 6 witnesses in this matter, and that was October 12th, 2018, and the events testified to occurred at a graduation party, June 23rd, 2018. Started off with a little 6-year-old boy who was in a tent, and all of a sudden the little boy comes out screaming. There are 3 different lay witnesses who gave 3 different versions, but they all agreed the little boy was screaming and basically was holding his pants. One of the witnesses indicated that the little boy said, quote, tried to go down his pants. Another lay witnesses indicated the boy said, quote, tried to bite him there, unquote. And the third lay witness testified that he, quote, he tried to stick his hands down my pants. So I submit there's not clear and convincing evidence that a rape occurred in this particular matter, as several things. First of all, that there was no sexual conduct, And I have several arguments to support that very fact. There was DNA done. There was DNA done of the little boy's underwear. DNA came back positive on the boy's underwear. There's also DNA done. There's a penal swab done of the little boy. Came back negative.
When? How long after the incident did that DNA test happen?
He was seen, I think he was taken to the hospital shortly thereafter. So he was examined shortly thereafter by a nurse who testified and indicated they examined him and took a statement from him. No indication, no medical records, no evidence that there was any bite marks, that there was any redness, bite marks, or any sort of injury. Now I submit, obviously the allegation here, and this is a serious, obviously it's a very serious charge or a very serious case, but to establish fellatio, I submit there needs to be some sort of penetration. There needs to be some sort of penetration. And the very fact, even the court in its findings, even the court in its journal entries, indicated that in finding facts, little boy said he stated that McCain, who had also emerged from behind the tent, had gotten down his pants and had tried to bite me down there. I submit trying is not a completion of the act. Now, this is not a fun case, but no stretch of imagination is a fun case. But from a legal standpoint, legal definition, he tried to bite me down there. That's more of an attempt. That's an attempt. That's not certainly completion of the act, and there's no physical evidence to support it. First of all, the 6-year-old boy didn't testify. Second of all, there's no physical evidence, independent physical evidence, that there's anything done in terms of, to put it bluntly, my client's mouth actually going on the boy's peanut parts.
No physical evidence, but there was an interview, wasn't there, where the child told the interviewer that the defendant bit him?
That's what he testified to.
Yeah.
That's what the interviewer, the medical person, yes, the medical person did say that. But in these type of situations, as we all know, there's a serious, thorough examination done. We have SANE nurses, there's rape kits done, DNA was collected, nothing on the penile swab, but it was on the underwear.
Well, in terms of the DNA on the underwear, did anyone testify as to whether that was amylase or something different?
Yeah, I don't recall. I just think they said it was DNA on the underwear, it was positive for DNA on the underwear, but nothing on the penile part. Yeah. So I think there's a certain distinction there, and I think the evidence, the record speaks for itself. I also made the argument as to force. I understand the case law as to what force is when it comes to these types of situations where you have a young child. But I think the other thing we need to keep in mind here is that if you're getting to this type of offense, I think you need purposely. You need purposely, and therefore you have to have specific intent. Again, it's unquestioned, Mr. McCain's IQ is 44. Is he able to form the requisite intent to even commit such an act under the purposely part of the statute as to the rape?
Well, counsel, it's kind of circular. You had me thinking about that because we're not here with him in a regular trial.
Right.
This whole hearing is by virtue of the fact that he was found not competent
Correct.
to stand trial. So how would anybody ever have the requisite intent? Not to mention the fact that when he was asked why he did it, he said because he wanted to. But if you just put his statement aside there,
Right.
how could you ever get them?
And I was thinking of circular, it's sort of a catch-22 situation. I've tried enough insanity cases, and we're not even at that level. We're at the competency level. So just an issue I raised when you're going to the specific intent here, and the main thrust of my argument is that there was not a rape. There's not a rape, which would subject him to life incarceration. Now,
You're saying at best it was evidence of an attempt.
at best. I'm not questioning the GSI, not questioning the gross sexual imposition. There's touching, there's DNA on the underwear. That's kind of a stretch for me to make that argument. I'm submitting that there's not a rape. There's no penetration, there's not a rape, there's not the act of fellatio in terms of, even by clear and convincing evidence. Obviously, we know clear and convincing evidence, somewhere between preponderance and beyond a reasonable doubt, but I submit that the evidence was not sufficient to sustain the clear and convincing evidence, and even the trial court in its findings relied on the fact that he tried to bite. So it's an attempt at best, or worse for that matter. So I'll reserve the rest of my time if the court has no.
You'll have the full 5 minutes.
Thank you so much, sir.
All right, good morning, counsel, you'll have 15 minutes.
Good morning, Your Honors. Thank you. I'm Vince Felucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio in this case. The sole assignment of error, as was mentioned, has to do with whether there was clear and convincing evidence of the rape in this case after Mr. McCain was found to be incompetent. And there's this standard under 294539 of clear and convincing evidence that is obviously a lesser standard than beyond a reasonable doubt, and it's to the court. The standard of review on appeal actually is that judgments supported by some competent, credible evidence going to all the essential elements will not be reversed on appeal. So that's what this court is determining, just if there is some competent, credible evidence supporting that rape charge. McCain refers to the 3 eyewitnesses from this graduation party, Mr. Abahazi, Ms. English, and Mr. Reek, claiming that what they say is somehow very different or inconsistent in some way. I would submit to this court that the statements of those three individuals are not inconsistent and they're not mutually exclusive. Mr. Abahazi testified that the victim came out of the tent and stated that McCain, quote, tried to go down his pants. Mr. Reed testified that the victim said McCain, quote, tried to stick his hands down my pants. Ms. English testified that the victim said McCain tried to bite him there as he pointed to his midsection area. The victim easily could have said all three things, or maybe Mr. Reed and Ms. English just remembered what was said in some more detail. That tried to go down his pants, tried to stick his hands down his pants. Those are nearly identical statements. They're just the latter has a bit more detail to it. It's a bit more specific. Victim could have said that Mr. McCain tried to put his hands down his pants and tried to bite him down there. In fact, I would submit that one thing would probably have to precede the other thing happening. The focus on the word tried in the statement of those three witnesses that completely ignores the testimony of Ms. Dudley, the diagnostic interviewer from Akron Children's that was discussed. To answer Judge Hensel's question, the victim presented to the hospital 3 days after the incident. That's when the rape kit was done as well. And the victim told Ms. Dudley there was no tried about it. He said he was at a friend's house, and an adult male he didn't know took him into a tent, and in the tent, the male used his mouth and bit what the victim called his pee-pee. That's what he said. He didn't say there was no tried about it there. To explain what he was referring to, the victim, as he was saying this, pointed to the area of his midsection, his penis. So he's clearly describing Mr. McCain performing the act of fellatio to this diagnostic interviewer at Akron Children's. And I think yes, Judge.
Well, did the trial court rely on that testimony in its finding, in its entry? Or did it just say, tried, as Attorney Rice has said?
I think it said, I don't know that the court went into too much detail in terms of what it was exactly relying on, but it did find clear and convincing evidence of the rape, not of the kidnapping, the rape and the GSI. But I would submit that is clearly very compelling evidence in this case, in addition to the DNA evidence, which McCain tries to downplay in this appeal, but that was also very compelling evidence, and it's not something that you have in every sex case. In fact, in many sex cases, you don't have any physical evidence at all. Here you did have very compelling physical evidence that included Mr. McCain as a possible contributor to DNA found on the inside of the victim's underwear. BCI scientists testified the frequency of the occurrence of that DNA profile would be rarer than 1 in 1 trillion.
What type of,
rarer?
do you know the answer to Judge Callahan's question when she asked what type of DNA was found on the underwear?
And as she asked that, I was flipping through the transcript to make sure it was if it was there or not, but it does not say if it's amylase or exactly the nature of it. It just says DNA. So that is what that's what is reflected in the record. The state did not need to have evidence that the DNA was actually on the victim's penis, as Mr. McCain is suggesting, to have clear and convincing evidence here. As I said, many sexual assault cases are not based on any physical evidence at all, and just the testimony of the victim is found to be beyond a reasonable doubt. Here we have a clear and convincing evidence standard, and you're looking at, is there some competent, credible evidence here? So to say we not only have the victim saying he did this, he performed fellatio on me, we have DNA evidence from his underwear that supports that. So that is more than, I would submit, clear and convincing evidence. I do want to address the issue of force, because that's addressed in the brief as well. The idea that the state did not prove that McCain purposely compelled the victim to submit by force or threat of force. The indictment actually charges this under the A1B, the under 13 section of the rape statute, but then there's an additional clause about force, and that actually just that enhances the potential penalty in the case. And I would just refer to the Dye case. The Supreme Court of Ohio talks in detail about the force element, especially when it comes to the rape of a child, and talks about the fact that it's nearly impossible to imagine the rape of a child without force involved. That's the quote. It says, clearly a child cannot be found to have consented to rape. However, in order to prove the element of force, the statute requires that some amount of force must be proven beyond that force inherent in the crime itself. So there does have to be some force beyond what is inherent in the crime of rape itself. Yet it says force need not be overt and physically brutal, but can be subtle and psychological. As long as it can be shown that the rape victim's will was overcome by fear or duress, the forcible element of rape can be established. And they also stated in that case that the Dye court states 290702B requires only that minimal force or threat of force be used in the commission of rape. And then they say, and I think this is particularly applicable in this case, the force and violence necessary to commit the crime of rape depends upon the age, size, and strength of the parties and their relation to each other. In this case, as was mentioned, we have a 6-year-old boy is the victim, and it's not, I think, if you look at this language, it's not meant to be a difficult proposition for the state to prove force in a case like this. I would submit that all the circumstances of this case show that McCain purposely compelled this victim to submit by force or threat of force. The 3 witnesses said they heard a child's screams coming from a nearby tent at this party. Shortly thereafter, you have the victim coming out of the tent, McCain coming out right after him and standing next to him outside of the tent. I've already mentioned what the victim said, or what these witnesses say that the victim said at that time, as he points to the area of his midsection, and then later what he told Miss Dudley at the hospital, getting into some more detail a few days later when he's not in the heat of the moment there. Again, pointing at the area of his midsection as he's saying that. The 6-year-old victim in this case could not possibly have consented to sexual activity, sexual conduct with McCain. The will of the victim, the 6-year-old boy, was overcome by fear and duress. I think that's indicated by all the facts and circumstances, and that force was proven as well. Again, that only goes to the sentence in this case. Is there any further?
I just had so we have a 6-year-old victim who talks to the therapy person at the hospital. There's no inquiry as to whether or not the 6-year-old is a competent witness because he doesn't testify at the hearing. We don't go through one of those
Correct.
inquiries, and yet our review is whether or not there is some competent, credible evidence. Was there any discussion below about the nature of the evidence as it came from the victim in this case, 6-year-old child?
I don't, in terms of why the child did not testify, or why the child was not competent, would have been. I don't think there was.
It's presumed to be competent, credible evidence, then, is what you're arguing.
I think so, unless it's somehow proved to be otherwise. There was no competency evaluation, like you said, so we're relying on what he's told 3 people in the heat of the moment after it's happened at the incident, and then what he's told later to this forensic interviewer. and I can't tell you, I don't think it's in the record exactly why the victim does not testify here, but I think that's, you know, somewhat understandable. When you have a 6-year-old, you don't necessarily want to expose them to getting on the stand, testifying, and so forth.
And then when the individual from the hospital testified without objection?
In terms of, was this medical diagnosis or treatment and that sort of thing?
Any objection?
I don't believe so.
Okay.
And I don't believe if there had been one that would have been successful. I think that was a clear exception to hearsay.
Right, I guess please understand, I'm not throwing up things and asking that you try to punch it, but when, you know, it's just I was wondering if the record reflected any type of inquiry or objection regarding that issue.
I'm 100% positive. I don't believe there was, though. I don't recall that being a big point of debate.
Did you want to address mens rea at all?
In terms of his,
In terms of appellant's argument? You have to.
yeah, I mean, the section, as I mentioned here, is A1B, which states, no person shall engage in sexual conduct with another who's not the spouse of the offender when the other person is less than 13 years of age, whether or not the offender knows the age of the other person. So I don't think mens rea was a big issue down below. I would then just ask that this court affirm the judgment of the trial court. Thank you.
Thank you. And you'll have your full 5 minutes for rebuttal.
Thank you, Your Honor. Forgive me. May it please the court. I'm going to talk about 2 points. I'll talk about the force, I'm going to talk about the competent and credible evidence. So let's talk about the force. Let's talk about the force element. So count 1 is a rape count, but there's additional, furthermore specification that the offender purposely compelled the victims to submit by force or threat of force. Where is the force in this case? Where is the evidence of force in this case? Remember, the incident happened inside a tent. No one viewed the incident. The only people inside the tent, the appellant and the 6-year-old boy.
Well, counsel is a screaming, crying child, circumstantial evidence of him not wanting that to happen.
Well, I had twins, so I had twins are in their 20s now. So my kids cried and screamed. I think that's what kids do. Is that independent evidence of force, though? There's a separate finding. There's a separate requirement. There's a separate element.
Sure, that's
For
what
this
gives
way.
you the life.
Correct, exactly. That's what puts them in, the guy gets them that life without parole, correct. But Revised Code 2901.A1 defines force as, quote, any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing, unquote. Case law from the Ohio Supreme Court indicates a defendant purposely compels his victim to submit by force or threat of force when he uses physical force against the victim or creates a belief that physical force will be used if the victim does not submit. Here, the 6-year-old boy didn't testify. There's no evidence of violence, compulsion, or constraint. Yes, there's evidence that he screamed. Is that enough to sustain that element of force?
Well, it was more, as I recall, it was he screamed, he was holding his private area, and there was testimony that he seemed extremely upset, shaken, something to that effect.
And again, I'm not denying that.
Yeah.
Is that enough to sustain the element of force? And here, all right, so let's talk about the timeline here. So this happened June 23rd, 2018.
And his shorts were unfastened, I think.
Right. June 23rd, 2018. He doesn't go to a medical provider until 3 days later. So we're talking about competent and credible evidence. If there truly had been bitten, think about a 6-year-old boy being bitten and just, you know what. There's going to be some sort of physical indication or something. Why isn't he rushed to the hospital right away? Why isn't EMS called? Why isn't he taken to a hospital provider? Sort of a practical argument, but it kind of makes sense. Wouldn't you, if your 6-year-old got injured, got hurt to the point where needs immediate medical attention, or there's redness, or there's something, wouldn't you need something to document that?
Would you need that in a rape case?
Not necessarily, but if you're a parent and the 6-year-old boy didn't testify, so we're stuck with everything outside his potential testimony, which means 3 days later, he is talking to and being observed, being seen. And again, no DNA on the penile swab went through 3 days. I mean, that makes sense. It's probably not there. But there's no photographs taken. There's nothing to indicate redness, bite marks, tearing, bruising, anything, nothing.
But, I mean, was there any objection at the hearing regarding the competency or the credibility of the evidence as it was being given by the person from the hospital?
No, and I think under the hearsay rules, that sort of testimony would be able to come in as for purposes of medical diagnosis or treatment. But again, I'm not sure that's this court's rule here, or even the trial court's rule, even if it was objected to at that point. But I think what this court has to do is, this court obviously, as this court knows this rule, take a step back and see if there's competent, credible evidence to even support that finding of basically fellatio in this case. But wouldn't it make sense to, if there's bite marks, and that's truly what happened? I mean, again, here's what the court found. Try to. So I don't think there's a force. More importantly, I don't think there's enough for the actual rape, even by clear and convincing evidence. And I'm going to be asked that finding be vacated and/or reversed. Thank you.
Very good. Thank you both for your arguments. In this case, the court will take the matter under advisement and issue its decision in due course, and you'll be notified of the decision on the day it's released. When the clerk mails you a copy of that decision. The court also is going to be sitting in Summit County